Are we ready to bring the jury out?
We are.
Before we do that, I would just like to say a few words to the folks in the gallery. In a few minutes, we're going to be receiving the jury's verdict. I just want to remind you about the importance of the decorum of the proceedings and that you're to refrain from any outbursts or emotional responses, whichever way the verdict turns out. So, thank you. And with that, let's bring out the jury, please.
Talking about the victim not taking the stand, the reason that the prosecution said that he couldn't take the stand was because when he went and revisited the actual incident and watched it on video, that he suffered an extreme attack, PTSD, and he really just couldn't even talk about that.
Yeah, it's but the bottom line is the jury heard one version of the story. The biggest problem is the 6 shots. I mean, he told a great story. He said he saw this person coming at him and he feared for his life and said he was threatening him and his family, so he shot. And then when asked, well, why'd you shoot him 6 times, including while he was on the ground, he said he just blacked out. He didn't have any memory, the old blackout memory. And that usually doesn't work, but you never know. You just never know. One thing that we should point out, this jury at lunch sent a note to the judge and asked if they could leave at 3 o'clock. We don't know what the response was there, but something triggered a verdict here. Obviously, they, after the lunch break, went back into the jury room, and jury's there. Let's listen in.
Thank you, Your Honor. Mr. Foreperson, could you please stand? Thank you, sir. As to the first charge ID, 228154C, which charges Jason Levesque with the offense of attempted murder, do you find the defendant guilty or not guilty?
Not guilty.
And the verdict is not guilty. All members of the jury, so say you all?
Yes. Yes.
Attorney Barth, Attorney Denhoff, would you like the jury poll?
No.
And as to the second charge ID, 22285155C, which charges Jason Levesque with the offense of first-degree assault, do you find the defendant guilty or not guilty?
Guilty.
And the verdict is guilty on first-degree assault. So say you all members of the jury.
Yes.
Attorney Sisti, would you like the jury poll? Thank you.
All right, thank you, ladies and gentlemen. That concludes your official jury service. At this point, I would ask you if you wouldn't mind staying for a few minutes in the jury room afterwards, if you have time. I'd like to come back and just have a few words with you afterwards, so I'll be with you shortly. Can you please ask the jury to be removed, or have the jury removed?
Please rise.
Oh, you can all. Counsel, is there anything further we need to discuss at this point?
Your Honor, with the attempted murder case resulting in an acquittal, we will ask the court to schedule a bail hearing so that we may be out on bail pending sentencing. They ask that it be sentenced, that we have that bail hearing within 10 days, first or second week of April.
Counsel, do you have a position on that?
Yeah, I accept that it's a material change of circumstances, and I don't object to the bail hearing, but certainly will maintain our position.
I think that makes sense. I mean, you're aware of what the standard is at this point. It's that this court has to apply, and so I will give you that hearing. So, Madam Clerk, do you have a date for when we can schedule a bail hearing?
Probably April 4th, if that works for everyone.
The 4th of April, I think, would work. That would be the best I can do the next week on the trial in Manchester.
We could do 11:30 if that works for everyone.
Thank you.
Very good. Very good. Thank you all. Well tried, Kate.
Oh boy. Okay, so Jason Levesque saved himself by taking the stand. They believed his version of events, despite his inability to remember shooting his neighbor 6 different times. He's found guilty of first-degree assault. The max in New Hampshire, you were doing some research, looks like it's about 15.
Looks like about 15 years, yeah,
But
that he could face, yeah.
Yeah, that would be the max, and he has got, he averted potentially decades in prison.
Yeah, I mean, not guilty on that top charge of attempted murder. Big development there.
Massive. Yeah.
Michael Jaffer is still with us. The victim didn't take the stand. He said that he was suffering from PTSD. He could not revisit it. You can infer from that testimony would not have been favorable to the prosecution had he taken the stand. Maybe you can. Michael, what do you think of that? If he would have taken the stand, maybe we would have had a different result today.
1,000%. That's exactly what I was thinking, right? I was a little bit surprised by the verdict, but obviously I defer to the jury because the jury only saw one side of the story, right? And this is why law schools teach you classes that have actually happened and not theoretical classes, because in order to predict the future, you have to understand the past. And so if you're a young prosecutor in New Hampshire or anywhere in the country, you look at this case and you say, wow, the complaining victim is so important and so key and so crucial, because it can only help the prosecution. It can only hurt the city. If you're the complaining victim now and you heard that he was acquitted, you have PTSD from the incident. Now you're going to have PTSD from the result. And man, and you see his attorney hug him, that's a lonely table, by the way, just so people know. Sitting at the defense table before a verdict is read, it's a very lonely place to be. Last time I was defending an attempted murder case, we got it down to what happened in this case, right? And that was also a shock, and it's lonely, it's crazy. But yes, you can infer exactly what you just said, Kelly. And jury, I defer to the jury on this one.
Yeah, I tell you, he did a very good job on the witness stand in terms of telling his life story. He was able to really go into detail in the days and hours before the event. He was plowing snow for a living. He brought along with him his child, and he had a really good relationship with her, who's now in college. You got to know him, and after getting to know him, it did change, because Michael, people present certain ways. You judge a book by its cover. Having him take the stand, I think it was needed, because it's self-defense was what they were alleging, but it also humanized what would otherwise be a kind of scary-looking character.
Yeah, you know what? I'm so glad you bring that up, Ted. I'm very heavy-handed in the realm of having a defendant testify. I think I go, I don't think I go too far, but people tell me sometimes I go too far. If you don't walk the plank in your own defense, the jury will look negatively against you for that. They'll have an adverse impact in their mind, because we're all here for you to decide whether or not you're guilty, and you're not going to take the stand. Him taking the stand and presenting as well as he did, just like you said, absolutely. That's why he got an acquittal on the top charge. There's no other reason. If he would have sat mute, there's no way the jury would have acquitted him. Like you say, he looked like Bigfoot, right? He looked like Sasquatch. And so he came out there, and then he humanized himself. At the end of the day, we ask juries not to convict robots, but to convict human beings. They're going to convict their fellow man, and they're going to look at you in the courtroom. If you don't take the stand, then you're not a human to them. You're just a person sitting at a defense table. They can have their imagination. Maybe they were bullied when they were younger in high school by a guy who looks just like you. Then you take the stand, and they're like, well, that's not the guy who bullied me. That's the guy who protected me from the bullies. You don't know. But at the end of the day, it only helps you when you take the stand and you humanize yourself. Obviously, some defendants shouldn't take the stand, but this guy, obviously, his defense attorney made the right call, and they made the right move.
Yeah. And then, again, it was a big win. Absolutely a big win.
Yeah.
Not guilty of attempted murder.